Hello everyone, we are back. We will now discuss Article 286 or grave coercions of the revised penal code. Previously, the penalty for grave coercion was arresto mayor and a fine not exceeding 500 pesos. However, with the passage of Republic Act number 7890 entitled an act amending Article 286 Section 3 Chapter 2, Title 9 of Act number 3815, Article 286 or grave coercions, now read as follows. The penalty of person correctional and a fine not exceeding 6,000 pesos shall be imposed upon any person who, without any authority of law, shall by means of violence, threats, or intimidation prevent another from doing something not prohibited by law, or compel him to do something against his will, whether it be right or wrong, and if the coercion be committed in violation of the exercise of the right of suffrage, or for the purpose of compelling another to perform any religious act, or to prevent him from exercising such right, or from so doing such act, the penalty next higher in degree shall be imposed. So in the second paragraph, you will notice here the constitutional right of suffrage and freedom of religion. So the penalty when these rights are violated is obviously higher than the impression correctional. And the term here starts with any person who, meaning the offender here can be a private person or a public officer. And there is the phrase without any authority of law. So what therefore does the phrase without authority of law mean? Well, it means that the person who restrains the will and liberty of another has not the right to do so as a private person, or does not act in the exercise of a duty in the case of a person with a duty to perform or without authority to perform said act. Therefore, in contrast to without authority of law, what does the phrase with authority of law means? So, the phrase with authority of law, we can only cite here examples like there is a police officer who restrains a drunk person. Well, he can do so as a police officer because he has the authority of law to restrain a drunken person. Another example is in the case of U.S. versus Calvo. Here, a doctor was requested by the family to restrain an insane person. Being a doctor, he has the authority of law to restrain an insane person. Another case is cited by the Supreme. Another case that we can cite is People versus Reyes. Here, a tenant can use force to prevent himself from being deprived of the possession of a parcel of land which he cultivated. He cannot be said guilty of grave coercion because as a tenant, he has the authority of law to protect his own property. Another example is the mayor under the case of Timonor versus People. Here, the mayor fenced a barber shop upon recommendation of the health officer. As a mayor, therefore, he has also the authority of law to fence or stop the operation of a barber shop. Next is, we can discuss here the two ways of committing grave coercion. The first is by preventing another by means of violence, threats, or intimidation from doing something not prohibited by law, or by compelling another by means of violence, threats, or intimidation to do something against his will, whether it be right or wrong. So there are two action verbs here, preventing and compelling. But before we proceed to that aspect, let us first discuss what are the elements of grave coercion. The first element here is that a person prevented another from doing something not prohibited by law, or that he compelled him to do something against his will, be right or wrong. So these are action verbs: preventing and compelling. The second is the prevention or compulsion be affected by violence, threats, or intimidation. So meaning the action verb of prevention and compulsion are not ordinary action verbs because they are coupled with violence, threats, or intimidation. So these are not simple prevention or compulsion. And the third element is that the person that restrained the will and liberty of another had not the authority of law or the right to do so, meaning, in other words, that the restraint shall not be made under authority of law or in the exercise of any lawful right. So the cases that we can mention under these authority of law are the cases of People versus Rimando, People versus Picunada, U.S. versus Tupular, People versus Kamats, or Timoner versus People. You can review there that these are the instances where the Supreme Court cited that the people restrained have the authority of law. Since we are just talking a lot about prohibited by law, we have again to remember that what is prevented here must not be prohibited by law under Article 266. Otherwise, there will be no coercion if what is prevented is prohibited by law. An example of this when somebody prevents a murderer from carrying a wicked purpose. That is preventing something that is prohibited by law. Because in grave coercion, the act of preventing by force must be made at the time the offended party was doing or about to do an act to be prevented. That is the case of People versus Madrid. So here, there are actually, as a review, there are two forms of coercion. Coercion by preventing, meaning prevent someone to do an act. Like, for example, prevent someone to harvest coconuts in a disputed land. Or coercion by compelling, meaning you coerce someone to do an act. Ang example here is when the accused took a 60-year-old woman to a kamatsili tree where they slapped her or maltreated her and took off her drawers and bound her hands for her to compel her to admit having stolen the clothes of one of the accused. Here, the woman here was compelled to do an act. She was compelled to testify an act. So what are other acts of preventing, or what we call acts of preventing an act constituting another crime? Meaning there are also other acts that fall within the ambit of preventing an act, but however they do not fall under grave coercion. An example of this is Article 132, Article 143, Article 145 of the Revised Penal Code. There are acts of preventing, but they are not grave coercion. So what is Article 132? Article 132 is a public officer who shall prevent by means of violence or threat the ceremonies or manifestations of any religion and guilty of interruption of religious worship. That is Article 132. And then there is also another article, Article 143, which defines as any person who by force prevents the meeting of a legislative body is liable under Article 143. Again here, the term preventing is mentioned. However, it is not considered as grave coercion. Then under Article 145, any person who shall force or intimidate any member of Congress from attending the meeting thereof, or expressing his opinion or casting his vote is liable under Article 145. Again, the term prevention is used here, but the said person will be liable under Article 145. 45. In the case of People versus Fernando, here compelling another to do something includes the offender's act of doing it himself while subjecting another to his will. Also in the case of People versus Juan, here the sergeant or police officer of the municipal town wanted to cross a private bridge, which was closed. However, they were refused passage because they were on a heavy truck. So what the accused did here was to open the bridge, grab and push the caretaker who fell to the ground. So one of them pulled out a revolver and was ready to shoot. So what was the crime committed? Here again, they committed grave coercion because the caretaker was compelled by means of violence to allow them to cross the private bridge. So we will now proceed to other acts of compelling an act that would also constitute another crime. Before we mention prevention, this time we will discuss compulsion or compelling an act. So, again, although these acts are compelling or compulsion, however, they are defined under Article 127 or Article 267. So, what is Article 127? It is a public officer who, not being authorized by law, compels a person to change their residence, is liable for expulsion under 127. Here, there's a compulsion or compelling a person, but the act is defined under Article 127. And then kidnapping the debtor to compel him to pay his debt is not only coercion but kidnapping for ransom because in effect there is a demand for payment that releases the said person from captivity. So that is Article 267. So we have again to be reminded that Article 286 paragraph 2 by compelling another means by means of violence, stress, or intimidation to do something against his will, whether it be right or wrong. So, what does the term whether it be right or wrong? It is not similar to illegal or being legal. It just means it being right or wrong. For example, here, a farmer entrusted his pig to his neighbor and later wanted to get back the pig, but the neighbor refused to return the pig, claiming that it belonged to another person. So, what the owner of the pig did was he took the pig from the neighbor by force. So, in the case of People versus Bautista here, is assuming that it was the right of A to take back the pig because it is his own property is still he will be liable under the law because he cannot compel B by force to return the pig to him. It's because it is considered as grave coercion under the case of People versus Bautista. So now let's proceed to the discussion of violence, threats, or intimidation. So what are examples of cases that there is a showing of violence, threats, or intimidation here? A taxi driver threatened to bump his car to kill himself and his female passenger if she would not go with him to a nightclub. Is he guilty of grave coercion? Yes, he is guilty of grave coercion under the case of People versus Remando CA 56. Here, the intimidation made by the accused that he would bump the car even both of them would die takes the place or equivalent element of violence. The intimidation here was intended to control the will of the offended party. So, we'll now proceed to another example here. What if a creditor, by means of violence, seized the personal property of his debtor? Is he liable under grave coercion? No, he is only liable under light coercion under Article 287. So, what if there is a group of people who would display their force by showing their arms and the body? Is there grave coercion here? In the case of People Madamba, what happened here is that the defendant, with 8 other individuals, appeared all armed and told the complainant to desist from constructing the house on a piece of land, and that the said complainant, evidently afraid of the presence of the armed man, desisted. So does this constitute coercion? The Supreme Court held that in People versus Madamba, there is no grave coercion because those facts do not show presence of violence since the defendant did not in any way intimidate the complainant. They just stood there. So they did not do any act that would show that they are intimidating the complainant. So we will contrast the case of People versus Madamba to People
Natakot
versus
talaga siya. So was
Erlanda. Grave coercion present here. The Supreme Court held that no, there is no grave coercion because it was contended that the delivery of the money was the effect of a threat made the day before. So hindi siya the same time. There being no actual imminent force or violence exerted upon the complainant at the time he delivered the amount, the accused cannot be held liable for coercion. So that is the case of People versus Romero. However, because the complainant here was threatened that he would be killed, he will be liable for the accused here will be liable for grave threat because there was a condition imposed upon and an act constituting the crime threatened to be committed, which is the act of killing the complainant. We will now hear the report of Divina Hinlo on grave coercion.
Article 286 of the Revised Penal Code is grave coercion. Grave coercion when committed by any person who without authority of law shall by means of violence, threats, or intimidation prevent another from doing something not prohibited by law or compel him to do something against his will, whether it be right or wrong, or be committed in violation of the exercise of the right of suffrage or for the purpose of compelling another to perform any religious act or to prevent him from exercising such right or from doing such act. The penalties: the penalty of prisión correccional and a fine not exceeding 6,000 pesos, or if the coercion be committed in violation of the exercise of the right of suffrage or for the purpose of compelling another to perform any religious act or to prevent him from exercising such right or from doing such act, the penalty next higher in degree shall be imposed. The elements of grave coercion are the following. First, that a person is prevented by another from doing something not prohibited by law or compelled to do something against his will, be it right or wrong. Second, that the prevention or compulsion is effected by violence, threats, or intimidation. And third, that the person who restrains the will and liberty of another has no right to do so, or in other words, that the restraint is not made under authority of law or in the exercise of any lawful right. For this felony, we have the case of U.S. versus Valcorta, 25 Philippines 273. The facts of the case: for the first element, that a person is prevented by another from doing something not prohibited by law or compelled to do something against his will, be it right or wrong. The accused entered a private house uninvited where services of the Methodist Episcopal Church were being conducted by between 10 and 20 persons and threatened the assemblage with a club, thereby interrupting or disturbing the divine service. For the second element, that the prevention or compulsion is effected by violence, threats, or intimidation, from the facts of the case, the accused simply threatened to assault them with a stick he was carrying if they did not stop the services. The people thus dispersed by the defendant were not holding religious services, as they were simply reading some verses out of the Bible. For the third element, that the person who restrains the will and liberty of another has no right to do so, or in other words, that the restraint is not made under authority of law or in the exercise of any lawful right. Neither the accused is a person of authority nor in the exercise of any lawful right. The record fails to disclose the purpose of the defendant in committing the acts complained of. It is true that it is shown that the defendant was of the Aglipayan faith, while the members of the congregation were of a different sect, but none of the witnesses for the prosecution state that the defendant made any comment whatever upon religion. The issue of the case is whether or not the accused is correctly charged under Article 223 of the Penal Code, which imposes upon any person who by means of threats, violence, or other equivalent compulsion shall force some other person to perform an act of worship or prevent him from performing such act. The ruling of the case: no. Under the circumstances and considering that it is not proven that religious hatred prompted the defendant to act as he did, his offense appears to be simply that of disturbing or interrupting the religious services. An essential element of the crime provided for in Article 223 was not proved, and the court erred in finding him guilty of the crime therein defined.